back. He reviewed the already admitted phone records of Mr. Merritt. He created a Google Earth presentation that is similar to the diagrams, I guess, that you would see that Mr. Bowles had already previously done from the exact same data. That Google Earth presentation was emailed with a link to Mr. Dougherty and I. Mr. Dougherty informed defense counsel of its existence. We did not know how to transmit it from Google Earth in that form, but we've offered them previously to come view it at their convenience. They've not taken us up on that. In further discussions with Mr. Dougherty, I believe it was conveyed to Mr. McGee in December, that before we started testimony, that Mr. Ray was most likely going to be called in rebuttal. I think I may have misspoke when I spoke to Mr. McGee during trial a week or two ago on the scheduling issue, when I lumped Mr. Bowles and Mr. Ray together on February 13th in that informal conversation, forgetting Mr. Dougherty and I's conversation about calling him in as rebuttal. So at this point, any material that he has prepared is based upon the already admitted phone records. That Google Earth presentation is available for view at the convenience of either counsel. And if they know the magic of how to convey that Google Earth presentation to them, I'll be more than happy to learn from them and transmit it to them. But at this point, Mr. Ray will only be called in rebuttal if they call their expert that they have retained.
And is this Google Earth presentation, can that be printed out?
No. I don't know if the court's familiar with Google Earth, and I'm not overly familiar with it either. It is satellite imagery of the planet. And you can kind of go anywhere in the planet in a map form. Somewhat similar to Google Maps, but with probably a little more detail. And it historically plots, so it's in what is similar to Google Maps. If you were driving from here to San Diego to the San Ysidro Plaza, and you wanted to stop off at the Fallbrook residence, you would enter directions and tell it, I want to stop at this point, and this point. It would create those points in a map for you and give you directions to it. What the presentation does with Mr. Ray is take the cell tower data that's contained in the phone records of Mr. Merritt, and it puts those in that essence as destination points within Google Earth along a timeline, which is the timeline of the records. And it just plots them out as they go and move through time and space.
So it's showing the location
of the cell towers.
Mr. Merritt's phone at various points in time.
Correct. Mr. Ray does something similar to what Mr. Bowles does with the pie graph based on the azimuth readings of the cell towers that's contained in the phone records. His looks more like a blob or an amoeba rather than a pie. So, but it shows the similar data or information that is contained in Mr. Bowles' stuff.
Okay. And Mr. Ray is not associated with law enforcement?
No, he runs a private company called ZedX, Z-E-D-X.
Okay.
Zed's
Yeah, Mr. McGee?
I understand how the Google Earth works. What apparently then, if this is what they say he's provided, is a data file that you load Google Earth, and then you can upload those data points into Google Earth and open it as a file. And then it will project onto your Google Earth programming within your computer to have that application on your computer, which I do. I have consulted with other individuals that have done that for me, so I know how all that works. So if they have the Google file, just giving us the file, I know how to read it. I don't need to go to their office to do it. I can actually forward it to our expert, and they can read it as well, so we know how to interact with it. Second, in regards to not only Mr. Gray, but Mr. Bowles, I see Mr. Bowles does have sufficient training, it appears, to at least offer some kind of opinion about historical cell tower data. It does not mean he has the expertise to talk about cell towers and their data sheets, nor does he have the necessary knowledge to talk about drive test data, unless they are RF engineers like Mr. Lipnitsky, Litnitzy, testified to when he was testifying as an employee of AT&T. I don't see neither Mr. Ray or Mr. Bowles has that in their background to testify to that. Mr. Ray is just appears to be self-taught. I don't know if he has the expertise to actually try and assign any type of blog which would show what a cell tower can or cannot see. I would like a report to show his qualifications, to say what his process was, why he's shaping them the way they are, see if he has the technical knowledge to actually say what they do or do not do. To represent that our expert does. He did that for decades in optimization and creation of those cell tower networks for phone companies. For his career, he is an RF engineer. He knows how all these systems actually operate. If he can tell me if what they're telling me, or what they're going to base their testimony on, or what their presentation will be, is consistent with the community to which covers that type of data, and whether or not it's based on reasonable knowledge of experts in that field, or if it's all made up. I know our expert knows of Mr. Ray. He has his opinion of what he knows, but I would like to have Mr. Ray and Mr. Bowles actually write a report saying what they're actually going to opine and how they got there, and not just maps, because maps don't tell us anything.
Well, you have the testimony of Mr. Bowles from the preliminary hearing, so you have a pretty good idea of what his testimony is and what his conclusions are.
And the report of the information that was provided by Mr. Bowles in an interview with Detective, I believe, either Hankey or Blockley at the time, also provided that. And there's a profound misunderstanding of Mr. Bowles' testimony and even Mr. Ray's testimony. They are just analyzing the cell tower data that is contained in the records of the report. Already heard the foundational testimony for.
Okay. And you do have a CV for Mr. Bowles, correct?
I do now. We received that when we got the email from Mr. I.
Do you have a CV for Mr. Ray?
Yes, that was provided months ago.
I think I do have a CV for Mr. Ray. Yes.
Okay.
That was provided way back when we were in
So really the only issue is at the time you testify, what foundation is laid as to what opinions they can give.
Or to what exhibits they want to present as well.
All those exhibits that I intend to use with Mr. Bowles have been marked since day one of trial, and they've been in discovery since 2014.
Sure. No, I mean, I understand what Mr. McGee is saying. I understand that there may be areas that Mr. Bowles is qualified to give an opinion on, and there may be other areas where he may not be qualified to give an opinion on.
Correct.
And I can only judge that as we go through the testimony of his qualifications and his experience and training. If it meets the threshold to give an opinion, it might not be the same level as someone else may have more expertise, better education, better training, better experience, but that goes to the weight of the opinion, not the admissibility. but there does have to be a threshold of either education, training, or experience in that specific area to be able to give an opinion. If he meets that threshold, then he can give an opinion, and then it goes to wait. If he doesn't meet that, he says, yeah, I know about X, but I don't know nothing about Z, then he's not going to be able to give opinions about Z. But if he says, I know a lot about X, I got some training and experience, so I know some things about Z, maybe that's enough to give an opinion about Z. Maybe the weight of it is less than someone else who has more experience.
And that is the defense's request, that we establish that foundation before they testify, because the foundation of that could be questioned or could be brought into question based on cross-examination. And if people ask some questions about something, the court may say, yeah, I think prima facie has been demonstrated, and we come back on cross, there's actually some issues that maybe it's not met, or maybe the court wants to rethink its finding. I prefer to be doing that before the testimony is given than after, and ask for no instruction.
I think with Mr. Bowles, I think there's enough from the preliminary hearing. I think I'm capable of listening to the qualifications, the training, the education, the experience in various specific areas. And then if there's questions that are outside of that, I think I can say, no, you haven't laid a sufficient foundation for that specific area. I don't think we need a separate 402 for that. I don't know anything about Mr. Bowles. I don't know what his CV is, so I would need to maybe look at that and at least hear what his. He may not even be called at this point. So
I can represent to the court the time he testified at the preliminary hearing. It was very rudimentary in his training. Since he testified, he has gone through more extensive training. That's why I think when I said into the section of my motion, based on the training now that he has received after he testified at the prelim, I think he has more details, and that's why his report changed slightly, or his graphs changed slightly. And so that I think the court will find. I don't know the extent of Mr. Ray's expertise in that matter. Obviously,
all right, well, we can address that. I might be willing to do a 402 hearing with regard to his general qualifications prior to the time they actually call him. But I don't think we need to do that now, since it's only a potential involved.
That's what it is.
Okay. And then we have Mr. Weitzman.
Mr. Weitzman, our concern is that we do have graphs. We do not have a report saying the information he reviewed, why he did the graphs what he did, and what his opinions are going to be. Again, the same thing that we had with Dr. Bruton, the same thing. We have exhibits without an explanation of what went into them. And we would like the report. We would like to have something. And if they don't have a report, and they haven't talked to them about it, then we would object that it's irrelevant, because we have no good faith, or they can make no offer of proof as to what he would actually apply to if they don't know. So what they're trying to do is present experts without giving us written notice what they're going to say. And that goes against everything about discovery that I listed in detail in my motion.
That was Ms. Rodriguez's department. She handled the CPA.
Okay.
Mr. Weitzman reviewed the defendant's bank accounts. Solely that. And his reports are labeled in terms of what each one is. So there's cash withdrawals, there's expenditures, there's an analysis of what he believes the defendant spent on materials and things like that. It's solely the defendant's money that he received from Joseph. Some of the money that is attributed to his accounts is anything that was written to iDesign, which was the defendant's company, or anything that was written to Child Merit.
So he's going to say there was a check that was written to I Design, there was a check that was written to Mr. Merritt, there was a cash withdrawal with some casino, there was
Correct.
whatever.
And that each one of the exhibits that he prepared is labeled in terms of what it is.
And the other aspect of the defensive objection is the timing. As I stated in our motion, we said to the jury in our opening statement, we have a financial accountant that reviewed everything, the government doesn't. And the government then after that, after opening statement, after testimony started, decided that's probably a good idea. And then they start their investigation. They have to establish good cause as to why this was not done before. And I will defer to the public or the people to express what good cause they think they had to wait until after trial started to start this part of the investigation, to where it affected not only our presentation, our plans, and then our defense and our argument, or not argument, our presentation to the jury during the opening statement. And now that's going to change because they're adding on to the investigation without giving a reason why they didn't do it before other than inadvertence or oversight, and neither of those are good cause. It has to be newly discovered evidence, which I don't think they have.
I don't think there's any requirement of necessity or good cause for additional investigation as the case goes forward.
But there is a requirement for good cause to get discovery outside of the 30 days before trial.
Well, that's true if it's material they have, but it's obviously not true for new material.
And none of it's new. That's our point. They're going based on the financial records that they've had since 2014.
Okay.
If I can be very briefly on that.
Certainly when Mr. Weissman testifies, you can ask him when he was first retained to review information, and I'm guessing he's going to say it was after January the 7th of 2018, or 2019. So, you'll have that, and if that's something you wanted to argue in closing argument, you will be able to do that. The testimony seems like it's fairly straightforward as to what it shows or doesn't show.
No, Your Honor, I'll have to weigh in on this. What they're trying to do is what they gave us is withdrawals from Merritt from the account. Everything that Merritt took out from his account, this person, Weissman, made a graph, a very misleading graph. And guess what? Guess how much of the percentage of withdrawals Mr. Merritt takes is attributed to gambling? If we had to guess between 0 and 100%. Of course, there's no foundation for it. 100% of what he did, he attributes to gambling, of every withdrawal. That's essentially what they're trying to do here. It's not just outlining the withdrawals and payments made to Merritt, because the records speak for themselves on that. What they want Mr. Weissman to say is that he, it's on 28, page 28 of our motion, but what they wanted to say is that all this is gambling money, and he only spent a fraction of it, because a fraction of it on cost of goods for the waterfalls. Out of let's say 100,000, he spent 2,000 on waterfalls. But he only looked at the withdrawals or payments to Merritt. He doesn't know that Merritt went out and then bought cost of goods and so forth. It's a very misleading presentation that they want to show in front of the jury. That's really what they want to do.
So that would be good for you to be able to expose it, right?
It would be, and believe me, I plan on exposing it if that's what he's going to do. But I just think it's a waste of time, because if you're going to give an opinion on use of cash, you have to look at all the records. You can't just look at withdrawals and then assume all of it is used for gambling.
Your Honor, may I?
Sure.
First of all, we actually had contracted with our in-house accountant in June of last year, prior to going to trial. We gave him the defendant's bank account, and he started doing a compilation of activity from casinos and things of that nature. Then, in November, we received a report from an accountant that the defense hired. And that accountant purports to put all of the essential elements and financial incentives to Dan Kavanaugh. And when we started looking at all of the information, which was not actually provided to us, I had to call their accountant in order to get the information that he reviewed. Then we realized, okay, this is a bigger job than our in-house accountant can handle, because he also has several other things that he does. So at that point, we took the work that he had done and gave it to a financial accountant to look at, to determine how reputable is this report from their accountant, and look at the work that our accountant did in-house and come up with your own analysis to determine what his casino withdrawal activity and things of that nature is. This was well before opening statements, so this characterization that we didn't hire him until January 7th is actually incorrect.
So is Mr. Winston going to be a rebuttal witness in response to their witness, or is it someone you're going to put on your case in chief?
I believe at this point it's going to be somebody we're going to put on in our case in chief, and his analysis of the bank records is what's contained in the reports that they have. And those are the bank records that they've had for several years.
So okay.
And just,
Okay, so everyone has the bank records. Everyone has an accountant looking at the bank records. And surprisingly, different retained experts come up with a different opinion.
No, that's not what it is. If that's what it was, no problem. Bring it on. They're not doing that because our expert used the proper standards, the proper accounting standards. What this person has done is just essentially looked at all the withdrawals and payments to merit and then said, it's all spent at the casino. And 2,000 of the, whatever the amount, 100,000 was spent on cost of goods for waterfalls, with no basis whatsoever behind it. That's a big difference than what we gave them, which is a certified forensic accountant statement using CPA standards that are nationally accepted accounting standards.
let me correct a couple things that Mr. Williams just said. One, we're inferring what they're going to testify to because they've offered no written opinion as to what he's actually going to say. We're just guessing at this point. So that may not be right because they didn't actually write what his opinion is. Second, they haven't provided us, they just told us now that Michael Neal with the district attorney's office, who I know I've worked with, reviewed everything, wrote reports, and provided to their experts. They didn't provide those to us, so they provided information to their expert, but they didn't provide us. So we would like those. If he made any opinions that were shared with their expert, Mr. Weisman, we would like those. We would like all the information that his expert relied upon. We haven't received those yet. The stuff that, the opinions that Mr. Moline is inferring from the reports, we don't have anything like that in writing. Our expert wrote a detailed, opinionated report saying what I found, and here's the evidence that supports it. So there's a distinction between what's been given and what's been received. And I don't want the court to have the impression that we know what their opinion is going to be if they won't provide.
Well, can you provide either a report or a summary of the conclusions to be offered by Ms. Wilson?
I would be more than happy to print out the information that we have provided to the defense that details his findings. He didn't write a separate report. He gave us drafts, and then he has charts, which I would be more than happy for the court to look at. They are very simple and very explanatory in terms of what they are, and they are based solely on the defendant's bank records.
And we do have the charts and the graphs. We do have it.
So,
What they need, or what they're going to say it needs,
I'll be more than happy to print them out because they are.
well, they haven't. They haven't, so that's not an issue.
It's not really anything that's subject to this grand interpretation, Your Honor. They're pretty clear.
All right, well, if you can print them out, let me take a look at them and I'll
Absolutely.
see if we need it. And what about the underlying information that was given to Mr. Weitzman that he reviewed?
He reviewed just the same thing, a compilation of bank record information.
did the in-house accountant do any preliminary reports that were given to the sportsman?
He did not do any preliminary reports. What he did was an Excel spreadsheet.
Okay. All right, we'll print out all the charts and graphs, and if I can figure out what they say, that means anybody can figure out what they say.
I assure you that.
That is definitely not my area of expertise. So that's a pretty low threshold. So if you can get that to me,
I can print them out right now.
well, you can get it to me tomorrow morning.
And if there's any discussions that they had with the experts that are talking about what opinions or what direction they're going, we would like that put down into a written form and supplied to the defense as required by law.
Well, I don't think they have to detail all of the discussions they've had with their experts.
But they do have to detail if there are like conclusions or what they will testify to. That's like an interview in his role.
Oh, sure. No, yeah. I mean, if he says, here's my quote report, here's all of my charts and graphs, that's my report. Okay, then that's it. But if he says, now let me go over these and let me tell you what they mean, then yes, I would agree you're entitled to that summary.
So that's all we have.
If there is such a summary, that would be helpful.
Yes.
But I'll still look at the charts and graphs.
I'll bring them in for summary.
Okay, thank you.
And on an unrelated note, was the court's thought, if scheduling can be adjusted, be dark on Monday the 11th, scheduling witnesses. I've floated the idea to the DA, since we're going to be dark on Tuesday, they're going to look at their scheduling, they don't know if it's possible, but just under the assumption that they could figure it all out, would the court entertain it, or the court could say, get people here anyway?
I can tell you right now, having thought about it since we've bantered back and forth about it, if we do that, then we're not getting to Mr. Bowles by the 14th, and that would mess up their expert. Because we would have to rearrange other witnesses. The other thing is, I believe on Monday we had scheduled a witness who was coming in from out of town, and those arrangements had already been made.
For Monday the 11th?
For Monday the 11th. As much as I prefer 4-day weekends as well, I also, we're at this point behind the schedule we had anticipated.
No, I understand that.
And that the court preemptively informed the jury of. So we're trying to keep as close to that as possible so we're not dragging this out.
It's just an idea.
That would actually work for me to be off on the 11th. There's something I might be able to do on the 11th. I wasn't going to take it off, just to take it off and miss a day of trial. But if the scheduling were to work out that way, I would definitely be okay with that. But if it doesn't, that's okay too. I mean, I understand we're behind our time schedule, and I understand everyone wanting to move things along. So,
If it can be adjusted, and we have to do goals the following week, then let us know ASAP, because we have it where we can adjust.
yeah, I mean, we would like to know
hotel.
about.
Right, yeah, because then we can make those adjustments with everything.
Yeah, I mean, I'm the bottom line is I'm open either way. Any other day I might have said, I'm reluctant to take an additional day off, but that day just seems, that happens to work for me, so. But I understand the concern of moving things along, and I understand the concern of witnesses already scheduled, which is why I didn't say, well, you know, it'd be nice, I think I need to take this day off, so I didn't do that. So, if it could work, that's fine. If it doesn't work, that's fine also. Okay?
We'll see what we can do.
Okay.
One last thing from our side is last Thursday, there was an attempt by Mr. Dowdy to elicit information from the interview that the defendant gave with CNN 2012-ish, 11-ish, somewhere in there after the disappearance. The court raised some concerns that seemed to raise concerns about its admissibility or whether the court would allow us to enter that into evidence. Before I stepped on a landmine in the middle of testimony, I was going to double check with the court that it's properly admitted as an admission. I understand that on Thursday, the nature in which it came to be broached was probably not the most sanitary or
Foundational.
Well, so I guess what I'm looking for is so we don't create issues that's going to cause delay. I'm asking to seek admission of that video from the court in advance to avoid any long sidebars or anything.
Because I think my only concern at the time was foundation.
Would you like to see it?
No, I think that when the foundation of the witness testifying to it.
Well,
When someone has to,
like I said, it self-authenticates.
that term actually never appears in the evidence code.
Well,
Everyone likes to use it, that a photograph or a video or something is, maybe some computer records come close to that, but
thus if the court views it, I think you'll see that it is properly authenticated.
I think you have to lay some foundation that from somebody that this was an interview and this accurately represents the interview. I don't think you can just say, oh, here's the tape from CNN, and here's what the defendant said.
And the court is correct. There is actually a Supreme Court case on that since in the digital age, things can be modified, so there has to be at least a foundation from a person that says that's true and accurate representation of that image.
That was my only concern with, I think it was brought up with questioning of a detective who said, basically was asked, are you aware of the CNN interview?
Well, the problem that we have with these interviews also is when it ends up on camera, a lot of it ends up on the cutting room floor. That puts it in context. So and depending on the producer or the director, how they're framing the show. And so that's the problem you have with, and I know the statement that they're going to try to make it seem like it means something, and that's the danger of those interviews.
Well, that goes to waste. If someone lays a foundation that Mr. Merritt was interviewed on such and such a date, and this is an accurate representation of that interview, that's fine. If you want to call someone and say, well, there was a lot more of the interview that didn't make what was there, that's fine.
Well, whatever
Maybe they have that, maybe they don't. They probably do.
If they have everything, then whatever they're getting as the foundational materials for that, they should have all of it.
My experience with those shows and interviews is they do an interview, they have lots and lots of material. They choose to air certain portions of it, sometimes in response to questions that are put in later. So what you're hearing wasn't really in response to that question. But at any rate, you have that, but they still have their original full interview. They generally don't get rid of those. That's been my experience. So, it doesn't seem like it would be that hard to get someone from CNN to say this was an interview that was done with Mr. Merritt on such and such a date.
Well, we know, I already know what statement they want to get in, and we already know that statement out of context already, so I'm anticipating that they're going to use it for the way it was used on the show, as opposed to what was really being asked. And so
Well,
forth.
that goes to a weight. I mean, if they can lay a foundation that Mr. Barrett was interviewed on such and such a date, here's the tape of the interview, they get to play it as far as I'm concerned. If you want to bring out, there was more to the interview, do you have the rest of the interview? You know, wasn't this said, wasn't that said? You know, fine, we can do all that. But I think there has to be a basic foundation.
I interpreted your hesitation as something else, so therefore your elimination of that issue is appreciated. And okay.
Yeah, that was my only, that was it. My recollection is my only issue at the time was you were asking the detective about something that was shown on TV, the interview of the defendant. And, you know, he can say, I watched CNN, I saw it, but that's not necessarily a foundation that it was an actual interview. So, basic foundation, then I don't have a problem with it. Okay?
All right, thank you.
No. You copy me the address. I think we're done.
I just have a couple of concerns
On the record of that?
on the record, but I brought up with you briefly last week on Thursday about your ruling with respect to the 1101 evidence and some of the questions that are being asked of witnesses about Dan Kavanaugh. My concern is that the people are being prejudiced to the point because we have to keep objecting to that information or these questions. And a lot of the objections are being sustained because they're asking for multiple levels of hearsay and things like that. And so the court, as I understood it, and we discussed last week, the 1101 ruling with respect to Dan Kavanaugh was related to the fact that Mr. Kavanaugh received payments from the business and that Mr. Kavanaugh sold the business. And my concern is we're getting into details and things like that and multiple layers of hearsay. I have concerns that because we're going to put a computer person on next tomorrow, that they're going to start trying to get into Kavanaugh's computer records and things of that nature. I guess what I would like the court to do is if defense would like to go into an area with a witness regarding Kavanaugh, that they provide an offer of proof as to how it doesn't violate the court's 1101 ruling. Because we continually have to object, and it makes it look to the jury like we're hiding something when we're complying with what the court ordered and what the court allowed.
Well, I made it clear that any dealings that Mr. Kavanaugh had with Mr. McStay and with inspired products, both before and after the disappearance, any allegedly taking of monies, whether authorized or not, the sale of the business, I think all of that is relevant. I think I indicated that obviously the statement, the testimony of a witness who says that Mr. Kavanaugh confessed to the killings, I said was admissible. Other areas either Mr. Kavanaugh's background, other comments he might have made in different contexts, I indicated are not relevant and not admissible. If counsel were to attempt to go into any of those other areas, intentionally go into those areas, that would be misconduct. And I would probably advise the jury of that at the time.
Well, I think the concern was raised when on Thursday the court allowed counsel to read verbatim hearsay lead tips from anonymous posters or callers. One was a post on, I believe, a social news organization's website, and read those verbatim, trying to point the finger at Dan Kavanaugh. Those objections to those were overruled, and then when Valerie attempted to go into other lead tips to kind of balance the yaw of the ship, the court sustained objections. And so the point, going into the lead tips, one, not only was multiple layers of hearsay, unreliable hearsay, when you are allowed to read them verbatim into the record, but they clearly are a backdoor into stepping around the limitations the court has placed on evidence relating to Mr. Kavanaugh.
Well, I think those, if I recall correctly, that was, the purpose of those was to show what information, if any, the detectives received, whether reliable or not, and what, if anything, they did with it. Did they ignore it? Did they follow it up? Did they decide it was not worth following up for one reason or another? So that wasn't really 1101B or 1101 evidence as to Kavanaugh. It was what information did the detectives have, and what steps did they take with regard to that information.
I understand the court's ruling, but when it butts heads with its third-party culpability ruling, I think the court can rationalize it on one hand and not realize that they're opening a back door that circumvents their previous ruling on the third-party culpability.
I understand there is at least a potential overlap between inadmissible detectives followed up on information that they may have received, whether that information is accurate or reliable or not. But those are two separate things.
And the reason why we start going into that was on direct when you open the door saying, you did a complete investigation, you exhausted all leads, and you exhausted all the suspects. Once they ask those questions, that opened the door to, well, are you sure you did? And that's the presentation of the argument we made to the court, that I think the court overruled the objections because based on that question, they opened the door to test that statement on that.
I will note for the record that is not the first time that's happened. There have been multiple occasions where there have been questions directed about Kavanaugh from multiple witnesses, and we continue to object, and those objections continue to get sustained. But by them continuing to ask those questions in front of the jury that they know this court has disallowed pursuant to the third-party culpability ruling, we are being prejudiced to a certain degree because it makes it look like we're hiding something. So I really wanted to put it on the record to make sure that everybody's on the same page with the court's ruling.
The same, that hasn't changed. And, as I say, if I think there are questions that are intentionally designed to elicit information that has been ruled inadmissible, I will not only sustain the objection, but explain to the jury why it's being sustained and that it's misconduct with counsel to go into that area.
I'm sorry.
But if it goes to another issue, that's different. As it was, as I saw it, was with regard to the issues of, well, did you have certain information and what if anything that you didn't follow up on? And indeed, Mr. Doherty did follow up on that with the cell phone records, I think. The cell phone records of Mr. Kavanaugh, bringing out that indeed That was subpoenaed by the sheriff's office, and the district, or search warrant was done by the sheriff's office and the district attorney's office for Mr. Kavanaugh's phone records. So,
Therefore, it's done. Therefore, I think really what our request boils down to, as long as we're all on that same page, is that rather than asking a loaded, factual question when it comes to Mr. Kavanaugh, knowing that it is on that line, that an offer of proof be made outside the presence of the jury prior to asking those questions, even if it's sidebar, so as not to ring bells in the jurors' heads when it's then going to just be followed by an objection and a sustaining. That clearly the Dan Kavanaugh line is a little blurry, that in order to avoid unintentionally on either side stepping on that line and violating the court's order, the proper process should be to provide an offer of proof to alert the court and counsel that this is the next question intended to be asked. Does the court believe it violates the ruling? And if it doesn't, then the court can allow the question to be asked. The problem is the loaded, very fact-heavy, loaded questions ring bells. They're not questions that we're allowed to ask on direct. Those are leading questions. They could ask them on cross, but that's where that becomes an issue. And I believe because of the court's ruling, because of kind of the fuzzy edges of that ruling, that we're asking for the appropriate process is to be heard prior to those questions being asked.
I'm not going to require sidebar conferences and offers of proof anytime there's questions about Mr. Kavanaugh. All I can say is, as I've indicated, if I think there's something that's intentionally violating the indemnity orders, which I think has happened a couple of times, and all I did was sustain the objection. But if it happens again, I will sustain the objection, and I will advise the jury why it's sustained, and I will cite the counsel for misconduct. So, obviously, if counsel thinks they're going into an area that might result in that kind of a reaction and wants to avoid it and wants to air that issue prior, I would certainly be open to that. I'm not going to require it.
And just so we're clear, Your Honor, since the people have asked numerous leading questions and got in information that is not supported by the evidence code, I assume if the court sees any misconduct on the part of the prosecution, then an objection is sustained, and the court is going to admonish the jury likewise, just for both sides.
If it were something that I thought was misconduct, yes. If it's just a leading question, which everybody does,
Yes.
no, you know. And some leading questions they're leading on direct, but it's foundational. It's not something that's really at issue. You know, oftentimes it's
Right.
but certainly if there's something that I think is improper that's being done, I have no problem. I mean, I shouldn't have to. I usually don't, almost never have to. But apparently in this case, maybe I do have to.
The judicial assistant alerted me to another issue that was unaddressed this morning. There was the packet of material that was emailed to Ryan Baker to use for the purposes of refreshing his recollection.
Well, not to Ryan Baker, it was emailed to the district attorney's office to Jeff Adams at the Commonwealth in Virginia. I emailed him I think it's 18-page packet that had 4 pages of the police reports, and then the additional 14 pages were screenshots from the QuickBooks accounts.
And I know that both counsel referred to it several times during the questioning. The court does have a copy, but it wasn't addressed whether the court wanted to mark that as like a court's exhibit for the record, given the unique circumstances upon which that was used.
It's probably not a bad idea. So what's our next order for court exhibits? So we mark court exhibit I as to the packet of information that was emailed to Virginia, so the assistant could read certain material that might be referred to. Did we ever get prints from the scene visit that we did?
Yes, there was a, oh,
We
I
can bring
forgot
those
about
in the
this. He
morning.
emailed those to me, I'll bring them over in the morning. Emailed them and I just forgot to print them out for you. I will
Okay.
print those out and make sure I have a packet for you.
So we'll do that, and we'll mark those as a court exhibit to be part of the record as well. And then I don't think we ever designated when Dr. Gray was on the stand, she had an exemplar of certain things that were passed around to the jury, and we photographed them, and those are court's exhibit G. Court exhibit G are the photographs of the exemplars that Dr. Gray passed around to the jury as examples.
Right.
Thank you.
Anything else?
Would you like us to find something else?
No.
I don't have anything.
Thank you.